I just finished all 51 pages of the judge's ruling in the case that Prince Harry brought against RAVEC so that you don't have to. We are also going to talk about the new information that was revealed in this ruling that has to do with the 2023 car chase in New York City involving Meghan, Harry, and paparazzi. Before we get started, this is just what I was able to take away from this document. I am not a lawyer. I am not someone who reads legal documents day in, day out. This is just my understanding, so please obviously take it with a grain of salt. Prince Harry lost his high court challenge against the Home Office for his personal security downgrade. A lot of this is about the procedure in which RAVEC went about deciding Prince Harry's status. What's hard, though, is that this document is heavily redacted, because obviously spelling too much out would give people too much information and make things more dangerous for the claimant. First of all, RAVEC is the Royal and VIP Executive Committee. Harry was protesting the way RAVEC decided that because of his change in status in the royal family, he would no longer be provided with the same degree of publicly funded personal protective security by the police when in Great Britain. Summing up some of the arguments that Harry makes in here, and one of the big ones is that it wasn't that they wanted to leave working royal life. They felt they had no choice but to leave, and that no longer being working royals wouldn't affect the threat level against them. Part of the claim that this was reckless and irresponsible and did not follow RAVEC guidelines was the fact that they did not run an RMB, which is a risk assessment analysis to determine the threat against Harry and Meghan. And I think a big part of this has to do with that this situation is somewhat unprecedented. There is confusion throughout the document of if Harry and Meghan still fall under RAVEC, if they are no longer working royals. Some arguments against RAVEC that the judge feels are beyond the scope of what RAVEC does. And again, some of it feels like they are trying to build the plane while it's flying. Sir Richard Mottram, who's a British civil servant, is quoted in his first witness statement in which he's saying that they were trying to devise something where an RMB would no longer be required because there will be alternative government arrangements. There's a lot of talk of a bespoke agreement when Prince Harry and his family comes to the UK. One of the things that they came up with was that Prince Harry's team would have to submit 28 days in advance his plans to come to the UK so that they could properly prepare and assess, which in some ways this just seems like more work for everyone. In RAVEC's defense, they have been able to come up with plans for Prince Harry in less than 28 days for emergencies, such as when Prince Philip died. There's also this interesting argument about privacy and paparazzi, because according to RAVEC, they are there to provide appropriate security when it comes to potential attacks on an individual. This brings us to what happened in New York in May 2023. The Home Office categorized what happened in May 2023 as a privacy issue, which Prince Harry did not agree with. That's where it gets kind of murky because RAVEC argues that that falls outside of their scope. Directly from the ruling, quote, RAVEC is concerned with security against persons bearing a hostile intent towards an individual, not those who, however recklessly, may cause danger in their efforts to get a photograph of a celebrity that they can try to sell to a media outlet, end quote. What's really important here is a letter from the Chief of Intelligence of the New York City Police Department from December 6, 2023. In which it's noted that contrary to what appears to have entered the public domain, the letter states that reckless endangerment did take place. In that letter, it was also discussed that there would be changes to the security afforded to the Duke and Duchess of Sussex when they visit New York next. I think that highlights a big difference here. The NYPD saw what happened and said, never again. We are going to find a way to make things safer, not just for Harry and Meghan, but for everyone around them. In comparison to the UK, in which RAVEC said, it's a privacy issue, not our problem. There is an argument that Harry and Meghan are no longer working royals. They do not get the working royal perks, which includes that level of security. But it's also completely understandable why Harry might distrust and be wary of what RAVEC deems to be appropriate security levels for him and his family. Maybe part of bringing the legal case forward was to set better parameters for the future for any working royals who decide to no longer be working royals. The argument that's also been made is that if Harry and Meghan are no longer working royals, they do not deserve the same level of UK taxpayer-funded royal security. It still doesn't explain why Prince Harry couldn't have just paid for it when he's in the UK. Yes, there's the nobody's above the law argument, but this is an unprecedented situation. And the idea that no longer being a working royal somehow changes the threat against him doesn't ring true. There's also talk in this document about a difference between providing security when they're in the UK and helping to transition the couple out of working royal life and what security they were afforded. In an email from January 28th, 2020, the recorded Sir Mark Sedwell, who's a civil servant, said that, quote, the state's interest was in handling any threat of redacted text, not in providing general security to facilitate the new role of the claimant and his family, end quote. Prince Harry and Meghan's then private secretary suggested that they shouldn't move too quickly in making these determinations because the Sussexes were developing their long-term plans and that their arrangement was subject to review in 12 months' time. As we know, and we'll talk about, that completely collapsed after a couple of months. But the decision by the state was in support of early action to recognize the new reality, which I'm not gonna lie, feels a little bit like punishment. So if RAVEC is in charge of providing security when people are in the UK, and that is their argument, let's talk about Meghan and Harry's general security, which brings us back to this December 2023 Byline Times article. This was when King Charles withdrew his £700,000 funding deal for Harry and Meghan as they transitioned to a new life in Canada. Financial sanction came after they defied demands of Prince William and palace staff over removing the name of former Kensington Palace press secretary Christian Jones in a letter before action, which was sent to Dan Wootton's former employer, The Sun. This happened in late June 2020 and is generally seen as what led to the collapse of the Sandringham Agreement, that whole 12-month trial period. One could argue that this led to Harry and Meghan rushing into some of these commercial deals when they now had to foot the bill for a £3 million-ish 24-hour security arrangement. The issue here is the blatant double standard. We have seen Prince Andrew around the same time not have his UK taxpayer-funded security pulled, despite the fact that he was forced out as a working royal. And King Charles picking up the tab to foot the bill for his disgraced brother's security. He was willing to do that for his brother, but not his son, his daughter-in-law, and his grandchildren. I'm not saying that that is a RAVEC issue. What I am saying is that's pretty shitty.